10, today I will be going over the CPA Planet Securities Regulation lesson. In this lesson, we're going to go over the 1933 Act and registration requirements, especially for exempt securities, which we'll talk about a little bit later, and exempt transactions. All right, so let's get started. Now that we know who should report and what the 1934 Act is, what exactly needs to be reported? By the way, the CPA exam does like to test on the names of the forms and what specifically they require, so make a note of this page. The Form 10-K is filed annually. It must be filed within 60 days for large corporations or 90 days for small corporations, and it must contain the value of the company's securities and financial statements audited by an independent public accountant registered with the PCAOB. You'll learn more about that in auditing. Form 10-Q is filed quarterly within 40 days for large corporations and 45 days for small corporations. It contains reviews of interim financial information by an independent CPA. Form 8-K must be filed within 4 days after a major change in the company. This change could be change in control, major asset change, officers, resignation of directors. Basically, anything major that happens in the company has to be reported on Form 8-K. Next, we're going to go over the 1934 Act reporting requirements of who exactly should be reporting to the SEC. Basically, all companies who are required to register under the 1934 Act must report. Also, 5% or more owners must report to the SEC, any tender offers, insiders must report, and also proxy statements must be reported. We're going to go over some of these in a little more detail. So owners of 5% or more company stock must register with the SEC. They have to inform the SEC of the owner background information such as source of funds, purpose, and buying the stock. Also, tender offers must be reported. A tender offer is an invitation by the buyer to the shareholders of a targeted company to tender shares they own for sale for a price specified over a period of time. Any party making a tender offer to purchase 5% or more of the company must report background information about the purchaser to the SEC. Insiders have to report. We just talked about insiders. Basically, officers, directors, more than 10% shareholders are insiders. They have to file a report with the SEC to disclose their holdings and make monthly updates in case anything changes. Proxy solicitations and proxy statements must be reported to the SEC. A proxy is a grant of authority by the shareholder to someone else to vote shares at a meeting. A proxy statement must be sent with the proxy solicitation. Basically, anytime a shareholder decides not to place their vote at a shareholder meeting, they can appoint somebody else to do it, and that's what a proxy statement is. And these have to be required to the SEC. So required disclosures for anybody that is required to disclose must disclose the names of officers and directors and the nature of the business and the financial structure of the firm and any bonus and profit sharing provisions included in the firm. Sanctions available to the SEC under the 1934 Act include the revocation or suspension of registration, registration denial, suspension of trading of securities, possible repayment of gains made illegally, possible sanction of individuals violating foreign laws, and possible identification of large traders to identify themselves. It's always done on a case-by-case basis, but just so you know, there are backlashes if anybody fails to report to the SEC when they're required to.